Good morning, good morning, good morning, and welcome to another Womanomics Africa online circle. I have lost count of what day of lockdown it is. All I know right now is that we're in level 3, certain relaxations. Top of mind as a working mother currently is the notion of kids going back to school. And there's also the reality that businesses are starting to scale up to go back and reflecting on what essentially the impact has been to date. And I know it must be over 80 days of being in a lockdown locally and internationally, what this means for their businesses. Womanomics Africa online circles are made possible by the support of Solidaridad and Oya that essentially provides support to make these sessions possible. The reason why we've been having these sessions is basically to stay on top of the conversations that are top of mind for women in business, as well as to ensure that we are walking a journey of being present to the occurrences that are happening around us, but importantly for businesswomen on the continent who are constantly on the journey of not just survival, but thriving and scaling up, understanding some of the considerations that they need to take on board. This week's conversation is highly topical as organizations are starting to deal with contract issues and enforcement of force majeure clauses and what that actually means for them. So with great pleasure, we introduce today's two contributors to the conversation, both from Covington Burling, and they're here to basically take us through the contract issues and policy and regulatory considerations in a COVID-19 impacted world. So it gives me great pleasure to introduce both Mosa, Mkhize, and Kgabo, Mashalane, to this conversation. And a brief bio about Mosa is that she is a policy advisor with Covington's Africa Practice Group, and she provides strategic policy and regulatory advice to clients doing business with and across the African continent. A non-lawyer, she has over a decade experience in this space and comes with a rich texture and rich experience in providing advisory support. Kgabo Mashalane is also on board with us this morning, and she basically is a qualified lawyer, and her experience is in advising the market on entry considerations, anti-corruption and bribery, as well as interactions with members of a government. What she's quite accomplished in doing is having practiced in project finance and in the development practice at Covington. So we have some highly skilled women on board today to navigate this conversation about contract issues. I know for one, as a business person, it's really got me thinking about some of those insurance clauses that we should be having in business, but also some of the kind of legal framework we should be making sure is not just always in place, but who are the kind of legal minds we should be tapping into when we're having these questions? And not just the legal minds, those who understand the policy implications and what the policy environment and regulatory considerations are actually allowing us to participate in, but also how those regulatory considerations impact us. Ladies, welcome on board to the Womanomics Africa circle. We are so glad to have you this morning, and we're looking forward to the content that you'll be sharing with us.
Good morning to everyone on the call, and thank you so much for taking the time to tune in. Thank you so much for that introduction. Just to start off, our presentation will be divided into two. I'll lead the first part of the presentation, which will focus on the COVID-19 contract issues. And the second part will be led by Mosa Mkhize, who will focus on the policy and regulatory considerations. And a special thank you to the Womanomics team for this valuable platform to talk about the issues that concern men and women, yes, in business during these unprecedented times. In this presentation, our focus is basically on the significant impact of COVID-19 on contract issues. Now, this presentation will consist of the following key areas. The first area will be an overview of contractual consideration. Second part will be the impact of force majeure contract issues. And the third part will be the impact of COVID-19 and, of course, a guidance on how contractual parties consider the host of commercial transactions with companies contemplating the costs and benefits of claiming force majeure relief. Due to this outbreak and spread of COVID-19 and the precautions put in place by relevant stakeholders in an effort to obviously minimize the spread of the virus, parties and agreements in South Africa are finding themselves in a position where the performance of contractual obligations are now either impossible or onerous to fulfill. So let's start off by defining what exactly is force majeure. I know a lot of misunderstanding can occur with this definition, but I think it's good for us to go back, because we know that now, since post-2020, the definition of force majeure may now change as we know it. But force majeure clause is basically a contractual term which regulates the consequences of supervening events beyond the control of parties on the obligation of one or both of the parties to the contract. Now, a force majeure clause typically require a causal link between such event and the performance itself. And so you need to provide for the consequences of the event on the party's obligation. Now, the event may result in the cancellation of a contract or excuse non-performance, whether it's in full or in part, or entitle a party to an extension of time or suspend performance as we know it. Now, just to talk a little bit more about the fact that COVID-19 has changed the landscape of contractual obligations as we know them. COVID-19 threatens the ability of contracting parties to meet their obligations or to perform as required under the relevant agreement regulating their relationship. Now, contracting parties may now find themselves in a situation where it is impossible to actually fulfill those obligations on time or at all. So at the same time, those parties may find themselves faced with non-performance or delayed performance by counterparties, and the impact of businesses in these certain uncertain times may be quite significant. So now, I guess the question is whether you are a party that is seeking to rely on force majeure clause, or the party that anticipates that force majeure clause will be relied upon. You first need, the starting point is to carefully review the provisions of agreements. Now, just to give you a little bit of background, when I was a project finance attorney, one of the important things and one of the challenges that we faced at the time was when non-performance, what exactly constitutes a breach of contract. And those are the kind of considerations that we need to look at over and above force majeure themselves, whether because of the fact that the definition of a force majeure post-2020 has now had to be looked at in a different light, because words like epidemic and pandemic have not been included or have not been part of a catch-all phrase. So I just want to talk briefly about, when we talk about a force majeure clause, usually what that really sets, or what it should include, and what typically is included in a force majeure clause. So the first thing that's important is what would constitute a force majeure by providing a list of such events. Number two, a catch-all phrase on what would constitute a force majeure, which we'll be discussing in more detail later on. The third thing is a requirement that a party seeking to rely on the force majeure clause must provide the other party to the agreement with a notice before invoking the force majeure clause for purposes of not fulfilling their contractual obligation. And of course, lastly, a period after which the agreement may be terminated by either parties without liability to the other for loss suffered if the force majeure continues beyond the period. So if an agreement, for instance, includes such a force majeure clause, parties may have to actually go back and rely on specific provisions of the agreement. And if an agreement, for instance, does not include such a clause, then the parties will have to rely on the common law principle of supervening impossibility. Now, I think this brings us to the fact that it's important, I guess, when you start the process of drafting a contract, to ensure that your clauses speak to supervening impossibility, speak to force majeure, speak to parts in an agreement that can result in non-performance. I think this is what it's all about. Whether you are dealing with a supply contract, a service level agreement, all the way through to a project finance agreement, it's important that the the drafter of the agreement, or your lawyers, are bearing those factors in mind. Okay, just talking more about this situation, about the fact that most force majeure clauses list a number of natural causes, as we know it, acts of God, so as we know it, such as hurricanes, floods, etc., man-made events such as war, terrorism, strikes, government orders, quarantine, etc. Together with a catch-all category that, for instance, can cause an outside basic catch-all, just basically a cause outside the control of the parties. Now, it is noteworthy to know that after 2020, prior to 2020, most force majeure provisions did not expressly list epidemic, pandemic, outbreak of infectious disease, or stay-at-home orders as an event that can trigger the relief or the excused delay or suspension or termination of a specific clause. Now, as a result, businesses are now asking their legal counsel to basically provide answers whether a pandemic constitutes and a current governmental shutdown order constitute as an act of God. So it's getting quite interesting. I mean, us as lawyers, it's quite an intriguing time to now go into deep interpretation of contracts and to see what are the ramifications. I mean, there's a lot at stake that the Covid-19 has presented in terms of these force majeure. So now, as I mentioned earlier, it's important for us to understand contractual considerations overview. It's important for us to go through basically what parties should review when they're looking at an agreement. Because what happens is when you review agreement, it's not so much about going straight into the force majeure clause, but you have to go back to the contract and look at it holistically, in the sense that you have to now go back and look at the breach, whether there's a breach of an agreement, whether there's a suspension variation or a termination of the contractual obligations. You have to now also look at the force majeure clause, and you also have to look at it, like I mentioned, holistically. Now, I'm just going to talk a little bit more about breach of agreement. Now, businesses should actually assess which of their obligations are potentially affected or disrupted, which might result in a potential breach of agreement. Now, the consequences of such breach must be considered and a plan implemented to basically mitigate such a consequence. For instance, let's give an example. A party might be liable for damages suffered by another party, and the type of damages must be assessed as they may be too remote, I guess, to the claim itself. So there is also a responsibility for a party to take responsible steps to mitigate the loss. Now, moving on to suspension, variation, or termination of a contractual obligation. Okay, parties seeking to be excused for non-performance may rely on either general common law defense of supervening impossibility of performance or a force majeure clause, as I mentioned. Now, I know this is very contract specific, jurisdiction specific. And when I mean jurisdiction specific, I mean in the sense that you have to now go back and look at the governing law of the contract itself. So I'm speaking right now in the context of a South African contract. So what normally happens is if contracts don't have clauses that govern force majeure in a way that makes it easier for parties to go back and just follow exactly what's in the contract, then we look at the common law. Lastly, as we discussed, the force majeure clause is an important part because it helps us to see whether there are circumstances beyond the control of the parties which prevent performance by one or both of the parties. And lastly, I just want to talk about supervening impossibility of performance. So this is a common law defense, and that suspends or basically in some cases it terminates parties' obligations where sort of like an irresistible force, a force that's unforeseeable accident, for instance, will prevent the parties from fulfilling the contract. And the defense applies generally to all the contracts and may be relied upon in the absence of a force majeure clause. So a starting point would be to find out whether the country that you are in or the country where the contract was concluded in is in fact a common law jurisdiction if there are no supporting clauses in your current agreement. Okay, so this is an important part. This is actually my favorite part of the presentation, because this is the part where we can now talk about what are the practical steps to consider should I be in a situation where now I have a contract, there's a force majeure clause, I'm not sure what to do, or I'm not sure whether this constitutes as a force majeure clause. But I think it's important to just look at some of the following key topics and practical steps to consider when exercising the rights under a force majeure provision because of COVID-19 at the moment. So the first thing that I'd want to talk about and bring your attention to is pay attention to notice provisions in the force majeure clause, okay? There are prompt written notices may be a requirement, okay? A party seeking the protection of a force majeure clause must actually follow all the procedural requirements in the force majeure provision, okay? Secondly, if either provisions of the contract offer more certainty, such as termination for convenience, change of law, material adverse change provisions, these are important to look at, okay? And thirdly, you need to examine whether triggering the force majeure may have unwanted side effects, okay? Such as the right for the other party to terminate, which is a reality. It could happen we've had situations in numerous times where basically the force majeure trigger basically it means that the other party can now terminate the contract, which now means there's a cancellation in the contract, okay? And then lastly, consider other relevant commercial provisions such as representations, warranties, and covenants, okay? For those that are in banking and finance and those that are doing project finance agreements, this is so pivotal. It's such a paramount part of the contract, because economic burden and like market hardships generally they're not excuses for non-performance, and thus bank covenants may need specific renegotiations in these instances, okay? And I just want to talk about as well changing approach, okay? For contracts generally being negotiated, you need to consider updating your approach by drafting a force majeure provision with the help of a subject matter expert, and usually that is done by lawyers. Okay, and just to make sure that I've reiterated this, considering establishing a central contact person, a contact point, I guess, within your organization to assist you with a couple of things like reviewing the relevant agreements is important. To manage these contract interpretation and questions. I've put this in because it's very important to remember that interpretation of the law is something that does need subject matter experts, and it will be in the best interest of your organization, your business, to make sure that you are covered should a unexpected, unforeseen circumstance like COVID-19 happens. How do you as an organization deal with it? It's good to know that now we're on level 3, we are slowly opening, the economy is slowly opening up, and we are at a place where now a lot of people have an opportunity to reflect and go back to and amend their contracts. I think it's a good time to go back and make sure that you have covered your tracks, so to say. Go back to your attorneys and make sure that you have covered your tracks. And I think it's also important to mention that you need to coordinate communication with counterparties, okay? These are the facts. Remember that these are fact and jurisdiction specific questions altogether. So this jurisdiction will be different to the next, and so on and so forth. And of course, this must be coordinated approach within your organization is very advisable. Thank you very much for your time and your attention. I really hope that this was insightful and helpful in making you understand that there is hope, in the sense that you can always go back to your agreements. You can always go back and find legal advice if you perhaps have not done that in the past. This is an opportunity to go back and prepare for the next pandemic. Thank you very much. I'll be taking it back to Rahima, and then Mosa will take over from there.
Thank you so much for that, Kgabo. It was quite You know, there's certain things that you've triggered for me that I would like some clarification on. I would just like to invite the participants as well on this chat to use the Q&A function. I see the chat function has been disabled, but to use the Q&A or raise your hand if you have a question that you would like to be addressed, and we will direct it to the panelists. Kgabo, I guess for some clarification, and as I was listening, I was thinking, gosh, the only law that I studied was probably in varsity, yeah, and just maybe 1 or 2 years, and the words and what is communicated, you're sitting back as a business person, you're like, what does that mean? And how do I translate that for myself? And I guess one always wants to see clarity, because there's some significant stuff that you were saying that we should be paying attention to. And I guess for me, I want to get clarity on a number of things. So you talk about the force majeure clause, right, in a project contract. If you haven't specifically factored it in, you say you revert to common law, right? So is it applicable to everybody, or also can everybody in this current pandemic, given that it wasn't part of the what you called it, all-catching language, what does that mean for an entrepreneur? Can you sit back right now and say force majeure? Can I, you know, to the person for whom you need to perform, say, I couldn't. We had a lockdown, I couldn't. Is this something that everybody can essentially call up, or is it restricted right now because of the languaging around that only to those who have it implied within their contract documentation?
Yeah, I mean, that's a great question, Rahima, and that's a question that's been asked in different ways, I guess. People want to understand, am I covered or am I not, right? And it's a valid question, because entrepreneurs now find themselves wanting answers, wanting to know, where does that place me? Where does that put me? You know, and of course, we always, like I said in the beginning of my presentation, what's important is to go back to the contract itself. Okay, that's what the law will always look at the contract itself and interpret the contract from there. And that interpretation will allow us, and like I mentioned, there are other ways of interpreting whether a supervening impossibility, for instance, is part of the common law. Now, COVID-19 is a supervening impossibility, and it's interesting to see that throughout the common law, you know, specifically a pandemic, you know, an epidemic, you know, lockdown, those type of things, ordinarily they are included in the common law. You know, so a lot of times we need to take it back now to saying, okay, the common law may not say specifically COVID-19, or may not say that a health, you know, crisis, but it's caused the common law now to shift and to actually include, you know, specific, you know, inclusions in that regard. So to answer your questions, entrepreneurs will be covered in that common law understanding of like a force majeure, you know, because truly speaking, just because that it wasn't included, you know, it's a question about whether it's an act of God. You know, I don't know if you saw in the beginning when I mentioned that it's quite challenging, because now the courts are finding themselves saying, okay, this jurisdiction will be different, this will be different. So we as well, we're watching it as it unfolds in front of us on what that means. You know, should maybe President Ramaphosa decide, okay, we're going back to level 5. What does that now mean again for those people that are now maybe have contracts that they have not been able to include a force majeure that includes an act of God? So it's a slippery slope, so to say, you know. But to answer your question, the common law does include supervening impossibility, because it is a supervening impossibility. If you are under lockdown, you can't do what you meant, you can't perform in a contract. You might even be in breach, because now you're not able to deliver if you're in the supply chain and so on. So that falls under the supervening impossibility.
Excellent. I see we've got one question coming up from Mamura, so I'll just give her the floor and allow her to ask her question. Mamura.
Good morning, everyone. Thank you for this opportunity and for the presentation. I just want the clarity. I don't know whether it will be relevant. I'm just a consulting organization that is not that big. So I feel, let's say I have clients, and let's say I contracted with one of the companies, brokers, whatever. And then during this pandemic, some of us, we are not really clued with the technology. You know, I'm old where I am. Now, we are used to visiting offices. You go to the office, everyone is not working. You try and make a call to the relevant people. You know, they make you wait until you drop the phone. Now, I feel like there's a breach of contract in the matter here because my things are not being attended to. I've got clients that I need to service, but I can't access. So is this not a breach of contract in these matters?
Thank you so much, Mama, for that question. I guess this now takes us back to, you need to go back to the contract between you and the other party, okay? Because that's where, do you have a contract in place at the moment, if I may ask?
Yes, remember, pandemic is new. So all this thing that I happened, there was nothing wrong before. The contract was going well.
Yeah.
Now, who do you find where during this period? Like yesterday, I went to another office. They say, wow, we have to refer you to this office. You go to this office, nobody's available because everyone's home.
Yeah, sorry. So I think what the best way to approach this, right, is to go back to, like I said, the common law does include, it's a supervening impossibility, because now it sounds like you're not able to move forward because now there's a deadlock in terms of your being able to fulfill your end of the bargain and they being able to fulfill their end of the bargain, which now brings you to a breach of contract because now you're not able to perform. So you need to go back and see what are the ramifications of a breach of contract in your contract. Let me give you an example. So some contracts have a breach of contract provision that will say, for instance, should a party not be able to perform due to the following circumstances, the parties can now claim damages. The party can claim special performance, which means that you can now order that person to whatever plan they need to make sure that you get your end of the bargain to be fulfilled, or number three, they can cancel the contract altogether. So I don't know if that helps you, but those are the kind of sort of remedies that the contract looks at for you to get to a place of where you need to go forward, either damages, specific performance, or you're able to just cancel the contract altogether. And that is defined as a breach of contract. You're able to get your monetary value of what it is that you have lost in terms of that agreement.
Thank you.
Sure, you're welcome.
Thank you for that. I mean, gosh, it does make one reflect. And I guess my last reflections on this is in terms of understanding the implications of triggering a force majeure clause.
Yes.
And one of the things you mentioned, you said, you know, be careful, because and what I said is that it could make it could cause grounds for that contract to be cancelled. I'm sitting back and I'm wondering, well, if it's not written in and the language is not quite there, can you insure against force majeure? Is that something you can insure your business against? Because I'm sitting back and looking as a business person going forward, and with you know, how I'm interpreting the environment, that pandemics, it's not the first time. I mean, on the continent, we've had things like Ebola. And so we are being made to understand it's not the first time. It's not going to be the last time. And so thinking about going forward, it's not just about making sure that the clauses are embedded within the contract environment, but there's some kind of insurance around it. Would you be able to comment on whether one can insure against this in some way to mitigate the impact either of the cessation of the contract or the impact of the, you know, what the non-performance period actually translates to?
Yeah, I think that's a great point. Insurance is something that we at Covington also sort of help clients navigate around, right? So over and above having a contract, it is very important to have insurance. And insurance, as you know, with the insurance broker, you'll have a contract between them. And I guess that's when the tricky part comes in, that when you are sitting down with your insurance broker, you need to make sure that now this has been covered, acts of God or supervening impossibility, things that are out of your control, right? And sophisticated insurers definitely do include, you know, pandemics, epidemics, things like lockdown, things like that. And you need to ensure that actually during that time, your contract between you and your counterparty is in place, number one. Number two, you yourself are covered in the event where, for instance, you don't have a provision in your contract that says that should you be able to perform, it's the fault of another party. Now, at least you have a fallback, which is your insurance to say that, oh, wait, but in the interim, I can actually go to my insurance and actually be able to claim back, you know, what I've lost in that contract, claim back what I'm going to lose in future. Because what happens sometimes is that it affects your future customers or your future, you know, just your business, you know, your business as a going concern is affected in that way. So I'll definitely encourage, you know, people to make sure that when they are having those agreements with other parties, that they do have an insurance in place. Let me give you an example. For instance, if you and I are in a contract and you are going to supply me with coal, right? And there is a period of time where you're transporting the coal maybe to me, and there's a period of time where we ask ourselves, is Rahima responsible should anything happen to the coal in transit, between the time that Rahima is delivering this coal to me and the time where I actually receive it, and something happens like COVID-19 en route, which we've had a lot of contracts or a lot of clients that are in those similar positions. What do we do, you know, in a situation like that? Who is responsible, you know, because that is an important question. Who's going to pay for it sitting in transit or sitting somewhere in a storage room and that sort of thing? Who's going to pay for the fact that now I can't trade, I can't do this, you know? So a lot of clients have actually come to the point where they are in negotiations between themselves, in the sense that they don't want to destroy their relationship, their contractual relationship. So they come up with a mediation, or rather an arbitration, to say, look, in this event, we're going to freeze everything, in the sense that we do want to continue to work with each other in future. However, as you know, there's this pandemic and I'm not able to deliver, you know, I'm not able to do this and this and that. In the interim, you go back to your insurance and be like, okay, this is a situation, I'm actually losing my money, what do I do? You know, so yes, there are a lot of contractors that have been sued during this time. There are a lot of contracts that have to be cancelled altogether, because it did constitute as a breach of contract, if we're being entirely frank with what the law says. So it's an interesting time and an unsettling time at the same time, but it forces us now to go back and be deliberate about our contracts, be deliberate about our waivers, our covenants for those that have project finance agreement, and go back to our condition precedents, you know, to see what exactly are the conditions that actually allow us to go on in a contract. So Rahima, I hope that's helpful. I hope that answers your question.
It does, absolutely. It also highlights for me the need for us to do a project contracting, fundamentals of project contracting.
I think that would be a great one. That would be a great one. I'd be happy to do that.
It's definitely something we should actually put together, so that, you know, in a post-COVID world, what are these new things? And we're finding humanity meets law. What do we need to start factoring in so that we are protected on all sides? And
yes.
Thank you so much for that, Kgabo. Great. Into the next part of the conversation, which is Mosa, because Mosa, you're talking more about policy, regulatory considerations. And I think I'm sitting here thinking the number of things that have changed, the regulations that have been impacting us just in terms of this lockdown period. What does it mean? As a business person, what are the kind of policy environments and regulatory considerations that are likely to impact us, that we should be paying more attention to? And not just for the news to come back and say something is now illegal, and yes, it's legal, and no, we can't. We don't understand this. Can you break this down for us? We really appreciate it.
Thank you so much, Rahima. Thank you as well as to Womanomics, and for inviting both Kgabo and I to the session. I completely agree with you. I mean, these times are certainly tumultuous, but also highly unpredictable, right? And we've seen over the past couple of weeks and months, I've also lost count, Rahima. Just for my mental health, I've just chosen to not even try to figure out what day we are on. And so I think it's important for us, I thought, given where we are kind of in the South African context, with now having moved down to basically, level 3, it's important to actually get an understanding of what does government actually consider in drafting, what are the things that they consider as a basis to draft the regulations that they have promulgated over the past couple of weeks. And so, for example, force majeure, as an example, becomes enforceable in the context of regulations that are defined by governments. So the question is, what are the factors that government considers in the context of defining these regulations? What trends have we seen in relation to public policy and regulations? And lastly, what lessons can we learn from a government and regulatory standpoint as we look to the future? And all of these points will be the focus of my presentation. I think now is the opportune time, similar to the points that Kgabo mentioned. Now is the opportune time really for us to reflect on our government engagement strategies as an example, but also to really almost, put our businesses in a way that they will be durable for the next pandemic, because none of us actually know what the future looks like. COVID-19 has happened in our lifetime now, but we don't even know when the next pandemic might be. And so, just to give a little bit of context in terms of my practice, Covington has a very unique capability through our public policy capability practice, which provides strategic policy and regulatory advice to our clients. And over the past few weeks, we've been particularly busy with, my colleagues and I, as we've supported a broad range of clients in as many sectors, with really analyzing, interpreting all of these regulations, which really are, conundrums in and of themselves. And even when we engage with some of the regulators who literally have defined the regulations themselves, they often find themselves thinking, oh my gosh, did we really publish that? Did we really promulgate that? And so, the COVID-19 has really presented a novel set of challenges for governments across the world. For the first time in all of our living memory, we found ourselves where high, middle, and low income countries were faced with a reality at the very same time. And what we saw for the most part was governments responding, in the best interest of their citizens. So for example, we saw countries such as the United States, who issued travel advisories encouraging their citizens based outside of the US to return to the US. And then closer to home, we saw other countries such as South Africa, Kenya, and others swiftly closing the borders to international flights, as an example, from high-risk countries. So our context as Africa is pretty unique, right? I think that we all know that we, on an annual basis, face the most dramatic public health burden in any given year, just given the constant fight against recurring and infectious diseases, which include HIV, Ebola, as you mentioned earlier on, and others. And with our high levels of poverty, urban density, widespread infectious diseases, limited access to healthcare, and overcrowded informal settlements, Africa found itself and continue to find, to kind of face a number of risk factors that threaten to exacerbate the current pandemic as well as future pandemics. So with this unique context, we saw government really considering a broad range of factors, but we kind of categorizing them into two buckets. The first one is public health considerations, and these really are broken down both from a health systems readiness perspective, as well as protecting the health of individuals and especially vulnerable communities. And then the second bucket is economic considerations, which we saw a balancing act between the impact of the pandemic of the economy, as well as on individual livelihoods. Next slide, please, Kgabo. And so, then let's turn then to look at what were government's responses, right? Because we're trying, now that we know, kind of on a broad level, what are the considerations that they look at in terms of, then defining and promulgating regulations. We saw the first one was really the declaration and impositions of national states of disasters, as we saw in many countries. So this involved restrictions being placed on the movement of people, closures of borders, and limitations of commercial activities, and businesses being restricted to those that were deemed as essential, right? So which for the most part were those in healthcare, emergency services, provision of food, etc. We also saw governments establishing national task forces, and these were comprised of experts and officials mandated to develop appropriate responses and to formulate regulations. So in Uganda, as an example, we saw the Presidential Scientific and Strategic Advisory Committee being established, and that was constituted of economists, anthropologists, my favorite word, epidemiologists, public health experts, virologists, and lawyers and policy professionals, etc., who all were mandated with designing and delivering effective approaches addressing, various aspects of the crisis. We also saw presidential task force drawing on Africa's extensive experience in terms of pandemic outbreaks. So Nigeria is a good example where they drew on the lessons from their 2014 West Africa Ebola outbreak. Sorry, excuse my kids at the back. So we saw Nigeria quickly setting up us. Sorry, just a second.
This is the reality of being live, right? And this is the reality we're all contending with in terms of, as a colleague has shared with us, we are now in their spaces. We are working at home in their space. So we need to acknowledge that these are not our offices. This is their home space. So we are actually intruding. So we acknowledge that and then we accept it and we move on.
So let me tell you something just on that particular score.
Just so happened, and
I literally moved my desk into my bedroom thinking that, what, this is a bulletproof solution. Nobody's going to interrupt me. But you know what? My son left his gum boots, his crocodile and dinosaur gum boots in my room, and he wants them right now. So,
and it has to be right now, right?
And it has to be right now. So anyway, as I was saying, really South Africa has drawn to a large extent, on kind of our experiences from previous pandemics, right? So for the purpose of this particular section and of our presentation today, I will analyze parts of South African government's responses to COVID-19 as we have seen it, right? So I think most of us would have seen that South Africa really implemented a really robust and comprehensive lockdown regime, one that's been applauded by, for example, the World Health Organization, for its, for really its robustness and the extent to which it relied on scientific, proof, etc. And where we find ourselves right now is South Africa is really kind of, opening up the economy. And as I said, this really provides an opportune time for us to reflect on lessons learned, and more importantly, to look at how we can, prepare our businesses going forward, knowing now what government actually considers, right? So towards the end of April, after considerable number of lockdown, we saw South Africa announcing their 5-level risk adjustment strategy, right? And, for a person like me, it's literally something that has, it sets the scene for understanding and actually how government interacts, right? Sorry, the basis on which government, considers the de-escalation process. We also have a full appreciation of how complex this is. So a number of our clients have just said, what is this risk adjustment strategy? We see it, it's beautiful, it's bright, and it's colorful, but we actually don't even know what it even means, right? And so we thought for the purpose of today's presentation, it might be useful for us to just look at it, interact with it, understand it, because the reality is that it's going to be part of our lives for the foreseeable future. I mean, I think just yesterday, I was interacting with some of our contacts, for example, in Minister NDZ's office, and just kind of getting some intel really in terms of what is government currently thinking, because none of us actually know. And just some of the feedback that I got is, listen, governments actually consider the strategy that they're working on right now actually forecasts into March next year, right? So all this to say, this risk adjustment strategy is here to stay for quite some time. And so now is the perfect time for us to really understand it. And so if we just look at it, right, we, as I said, it's a 5-level approach, which really looks at different levels of risk, which then also, you know, it defines and will inform certain restrictions that are certain regulations, right? And so, for example, for the first part of the lockdown, we were all in level 5. That was considered high risk, you know, high risk in terms of the spread of the virus, and also really, really, really low levels of readiness from our healthcare system. I think over the months, we've seen significant pressure being placed on government as far as, you know, them really having to listen to the plight of businesses, many of whom were literally just on their knees, facing possible closures, etc. And not even, you know, that aside, on a business and company individual level, we all saw the devastation on our economy. It was just painful to even watch. And as we all know, you know, our economy was already at a state of dire, you know, in a dire state, even before the pandemic, right? And so we saw government then kind of really considering very deeply the de-escalation onto level 4, which, you know, was really, was done without compromising on the health benefits that had been gained over the really robust level 4, level 5 considerations. And right now we find ourselves in level 3. Now, what we saw, of course, you know, we are a democracy, and a very robust democracy, and one that involves, you know, really engagement. And I think all of us will agree that in the South African context, Cyril Ramaphosa really is an engaging president, you know. And so even, for example, where we saw in the risk adjustment strategy, when it was published on April 23rd, for example, it didn't include, well, for example, tobacco sales were tobacco. There was a difference in where tobacco was ultimately then announced, and the same applied with alcohol, right? And I'm saying this because it demonstrates the very fundamental point about engaging with government, which I will include in kind of reflections on what we've learned during this time. So as things stand right now, we are in level 3, which is considered as a moderate kind of virus spread, and also in terms of our healthcare system's readiness, we considered ourselves kind of middle ground, right? But there is a possibility where we might see ourselves kind of the escalation might even revert back to level 4, possibly even number 5. And there's also a world in which, and the regulations allow for this, for different provinces to be at different levels based on their unique circumstances. So given, for example, politics aside, and I know we can never remove politics, but just for the moment, please just bear with my analogy. Politics aside, the Western Cape is in a very, very serious situation right now, as is the Eastern Cape. And that situation is very different, for example, to the Free State. So right now, even though, you know, South Africa in its entirety is in level 3, there definitely is a world in which, and the regulations, as I mentioned, does make provision for this, for certain provinces to be at different stages. Even more specifically, for different municipalities within different provinces to have different levels of to be allocated different levels. So, you know, at the moment as well, at this point, international travel is not even something that's an option. I saw late last night, the Department of Home Affairs issued directives which allow, which provide certain kind of guidelines in terms of what kinds of international travels are allowed. It's the first time that they've done this since the definition of high-risk countries. So that's a positive move. It's a positive step. It shows that, you know, the Department of Home Affairs is engaging on the reality that, you know what, there are actually some people that, for example, who may have gone to the US as an example because of their governments kind of recalling them to their country. But now that, for example, schools are opening, it's like, how is government actually dealing with this? And so this is an organic process. It's a process that continues to evolve over time, mainly based in terms of how government engages, where as the epidemiologists and the National Command Council, etc., what they decide and act on. Next slide, please, Kgabo. So, when the risk adjustment strategy was announced, a lot of people said, okay, but what has informed this strategy of yours? Is it something that just kind of, what factors did you consider? Because of course, it's not something that just kind of fell from the sky, right? And government was very clear to say that there's three core kind of considerations or pillars that they have that inform this risk adjustment strategy and inform the different levels, the allocation of different levels. And those are as follows. The first one is just on the risk of transmission. So basically looking at the extent to, the nature of the work for each industry, the profile of the workers. So for example, if you look at, a company such as ourselves, for example, our office is based in Rosebank, looking at the profile of the workforce might be very different, for example, to an industry that is based elsewhere. So for example, an industry maybe that's based in Soweto, where the work profile is very different. So literally government took it to very fine details in terms of looking at the transmission risk as being a core pillar. The second one was just looking at the economic value of the risk. So for example, they said very big contributors to the GDP, as an example, were given greater kind of allowance to resume economic activity because of the economic impact that continued lockdown would have on them. And then the last one was just in terms of the impact that continued lockdown would have on the business. And so, next slide, please, Kgabo. And so, what was then published is, each sector, and you can literally look, it says, so they didn't just lump everything together. They looked at each industry, looking at based on each of those three kind of core pillars. So for example, this slide looks at the economic value of each sector, and they broke it down. So looking at wholesale and wholesale and retail, and you'd look at then all of those different kinds of considerations that they looked at. Very different, for example, to insurance, very different, for example, to hotels and industry, very different, for example, to fishing, Then looking at the second consideration, next slide, please, Khabs. Looking at, for example, then they map everything out in terms of looking at the risk, risk of transmission, which is the second core pillar. And again, very sector specific, and scores then given to each, which ultimately then resulted in the allocation of each of those sectors according to the risk adjustment strategies. Next slide, please, Khabs. So for example, if you look, based on the calculation of that kind of those three pillars, then government issued then, kind of this categorization of each of those sectors based on the levels. Now, I think all of us, when we saw this document, it kind of caused a lot of panic because people said, oh my goodness, does my industry have to wait until level 3? Oh, when does that even, there's so much uncertainty, right? When will level 3 even happen? Will it ever even happen, let alone level 2 and level 1, right? And so, as I mentioned earlier on, this has been a pretty fluid process. Many industries have engaged directly with government. Others have literally been unable to do that. But this is the allocation of each of those industries based on the different levels. So on this slide, we see level 5 and level 4. On the next slide, we see level 3. And then on the next slide, we will see level 2 and level 1. So we are here today with, you know, through Womenomics, and we know that most of the sectors, I mean, most of the businesses, of course, are in the oil and gas and agriculture. And so on the next slide, please, Kgabo. Yes, over here, on this slide, we thought that it would be useful to kind of reflect on what is the evolution of the regulations, what has it looked like, and more importantly, how has it you know, impacted on the industries in which most of the community of Womenomics is involved. And so, you know, as mentioned, the deck will be shared with everybody, but we just thought that it would be interesting to just kind of synthesize these very convoluted, complicated, often unreadable regulations and to present them in this way. And, you know, so for example, you'll see when the national state of disaster was declared on between 15 and 21 March, it's very different to how things currently are. And I only did this presentation until level 4, which ended on the 30th, end of May, not 30th of June, because we're still in June. But all of this really just shows how the regulations have evolved over time. So for example, if you look at manufacturing as an example, under level 4, when the national state of disaster was declared, there was complete closure, right? And complete closure of all economic activities. But where we find ourselves now is that we moved, for example, in I think it was on 2nd April, 30% manufacturing capability was allowed, right? 50% mining activity was allowed. But where we find ourselves now is that actually 100% manufacturing and manufacturing capability is permitted. So all this to say, and all this to demonstrate the fact that regulations evolve over time, mainly based on the current circumstances, which are mainly based on the discussions held at the National Command Council level, which are constituted, as I mentioned, by government, professionals, lawyers, policy, etc. But ultimately, this is what it then looks like, and this is what we then have to interact with on a industry level. Next slide, please, Kgabo.
Mosa, I'd just like to acknowledge to the participants that we said 10 o'clock, we're so enjoying ourselves. If you can just give us, no, it's great, it's fantastic. This is precisely the kind of content that we're signing up for. But I just want to acknowledge the time for the participants and ask if they can bear with us for another 10 minutes, because we'd like you to have an opportunity to walk through the end of your presentation and for a bit of Q&A. So just acknowledging the time and just giving you permission to please continue, Mosa. Thank you.
Thank you so much. This is my last slide. So, you know, what are the lessons that we've learned? Okay, I think that, you know, from where we sit from a government engagement and public policy standpoint, is just 3 points and 3 lessons that we would love to share with this forum today. The first is just really on the importance of defining a comprehensive stakeholder list. I think if there's just one takeaway from this particular presentation, is that let's use this crisis to better prepare ourselves. I think that we've all seen that there are many doors that we would have loved to have access to and opportunities to engage on, but in times of crisis, all of those doors are actually just not available to us. And it's only having had prior engagements in many instances where you can actually just call on those people because you've had interaction. So the first is just the importance of defining and engaging, right, is the second part. And then the last part is just, there's so much power in engaging as an industry rather than, you know, Mosa's shop going to engage, you know, Nkosazana Dlamini Zuma as an example, and just the power in numbers. And I think that, you know, the work that is done at Womenomics as an example is a fantastic example of that. You know, when you have a coalition of like-minded and like-affected and similarly affected organizations and companies really engaging government. So with that brings my presentation to a conclusion. Thank you so much.
Mosa, how enlightening that was. I'm personally excited. Once again, an invitation to the guests to just raise your hand if you've got questions, and I will kick off the questions, or some of them are reflections from what you're sharing. And the first reflection I think that this lockdown has brought to bear is government's response. It seemed to be, for a government that has been challenged over the years with their lethargy and implementation and just a poor service delivery, we've seen their ability, just through the enactment of the Disaster Management Act, or the Disaster Act, the ability to corral resources, the ability to, to build confidence, because our staying away and adhering to some of the edicts that have been given has been a function of our trust in the government. So we've essentially demonstrated as a nation our ability to not just trust the system, but allow the system to work. But importantly, what the system was showing us, its ability to have efficacy and efficiency and expediency in delivering. So we've got to sit back and say, well, if our regulatory framework allows for such expediency, really, and by the way, we basically almost fell off when you said that this risk strategy is basically, we need to think about up till next year, March. We're sitting back and thinking, gosh, why doesn't government have these kind of risk strategies for their 5-year deliveries? Surely would be getting a lot more done. What is it that we are missing in that? But I think importantly is, for me, your reference to this risk adjustment strategy and the reflection as a business person is again, for me, an opportunity for another session for us to have around the risk management strategy as organizations are reviewing the different scenarios that are likely to prevail, and how to adjust even as they're scaling up back to business. How do we incorporate this risk adjustment strategy that government has, and how does that impact the entrepreneur in their planning? Obviously, strategic planning is a lot broader than just particulars in one scenario, but being that this is so significant and for a lot of organizations is a go, no go, how do we as organizations help entrepreneurs navigate what that risk adjustment strategy is, and how organizations should navigate their response to that, and how they factor that in their own strategic planning process? I think for us, that would be an interesting conversation to have in terms of how Covington and Womenomics Africa can frame such a conversation for entrepreneurs. I see no additional questions. I mean, that was so enlightening. Lebu and I were sitting, and Lebu is my partner, and she's silent at the moment, but she's definitely in the background and engaging with us. It's never a one-man show. Lebu?
She's floored by the March timeline. She just stopped thinking after that.
Oh.
She just March, and then she was like, no way. So.
Yeah. I agree with you. I mean, certainly on the first part that you mentioned, just on just being impressed about how we can just get government to move and to do things, and like to do so expediently, is, for me, it's been amazing. As you know, and I think that's a good question to pose to government, to say, but now we've actually seen that you guys actually have the ability to do this, right? But interestingly, I don't know if you would have seen, but I think about a week or so ago, there was a case in the High Court, and it's called the De Beer case. And basically that case, the High Court made a ruling or judgment to say that the regulations under level 3 and level 4 have been deemed unconstitutional and invalid. Yeah. So at this stage, we kind of all, and then shortly thereafter, Cabinet issued a statement to say that as Cabinet, they believe that a different court will have a different ruling or judgment. And so they have appealed the decision, and Minister Dlamini Zuma is being joined, the appeal is led by Dlamini Zuma, but also Minister of Health, Mkhize, and the President. So we live in fantastic and amazing times. There's never a dull moment in South Africa. While some of us are cheering government on for just being fantastic at just delivery, which is literally their number one KPI, others are saying, no, you've overstepped your over delivery. So please, so I think we certainly live in interesting times. I honestly see whatever happens is an opportunity, right? I think that now is the opportunity for us to reflect. Now is the opportunity for us to really define relationships that we've never even explored or even thought about. Now is the opportunity for us to go back to our contracts. Actually, for me, it's like, if this thing is going to be with us until March, let us have that session with Kgabo and let her just tell us what exactly we need to do. Even if that means we have a particular case study, you know, and I know Khabs is amazing at this. She will deep dive, you know, she will dig right in. You know, let's look at, for example, a case study and say, okay, here's a case study. Of course, we can't look at every single contract, but now's the opportunity for us to do all of these exciting things and to do it in ways that are completely out of the box, out of the proverbial box. So that's how we see it.
Indeed, there is no box right now. And so it's great. Lebo, do you have your hand up?
Yes, I also just wanted to mention as we close off, which we'll do now. I think the one thing that this has also highlighted for us, and I think particularly as women, it's most important, is this idea of collaboration, right? Because whatever the opportunities are showing up is really around saying, what does this new landscape look like? What has changed? And even though what stays the same, but what has changed, but then where are the opportunities for us to think about collaborating across different types of businesses, because that's where some of these opportunities can also be unlocked. As businesses in South Africa, I think one of the conversations that we are facilitating, and Rehema will say, I think we have it's the 22nd of June, right? We're having a conversation around the free trade agreement, and particularly around, is it still a stimulus package and what does that mean? And one of the conversations we're having with one of the speakers that's coming on board is around the fact that this is the time now for this continent to look at how it's collaborating with itself even more, because this has forced us to do this. So I think it's important that we're having these conversations around, what does this look like now? What does this collaboration piece look like at the moment? And how do we begin to unpack what those opportunities look like? So I'm as much as I'm floored by the March deadline, I think there's also a lot of excitement around how do we think differently and how do we do things differently? But yeah.
Awesome. Ladies, today was a fantastic conversation. We definitely gleaned a lot, and we are looking forward to our future collaborations, which we know are, things that we're planning on and we'll share at a later stage. We're definitely looking forward to that. It's really been insightful. And I think, Mosa, on some of what you ended off on is basically the opportunity in terms of collaboration. And I think that one of the things we've appreciated is that the policy and regulatory environment is not done in isolation without consultations, despite how fast things have moved right now. And there are opportunities in this world of thinking where there is no box, for us to start influencing what that is. Lebo has alluded to the African Continental Free Trade Area as an area of interest. And I think that as women entrepreneurs, we really need to start engaging with the policy environment, the regulatory environment, understanding how this shapes and affects our ability to do business. And as you rightly pointed out, whilst certain sectors and industries have had the ear of the presidency and the joint committee in terms of influencing some of those decisions, certain sectors haven't. That question has got to be raised about women's engagement as well in influencing some of these areas where our participation could either be elevated or compromised. And so I think the call, I guess, to everybody out there is engage with Womenomics Africa at events@womenomicsafrica.net. Call us, talk to us, contact us, and let's see how we can make this a platform for empowering and driving economic highways driven by women. Thank you so much for today's session. Anybody got queries? We will be sending this out as a YouTube video, so be on the lookout for that, and we will share that with you and all our associates. Till the 22nd of June, when we are talking about, is the African Continental Free Trade Area a stimulus package for the South African entrepreneur? We look forward to you tuning in. Cheers.